First of all, let me introduce myself quickly. I'm Stephen Neff, a professor of War and Peace at the University of Edinburgh, and I will be chairing this session. And an announcement, first of all, here about recording. The session will be recorded in general, but if you have an ideological objection to recording or something of the kind, then an alternative is available. You can turn your camera off and write your question in the chat box, and that can be relayed indirectly if you wish. But otherwise, just go ahead in the chat session or the question and answer session with your question orally. Okay, let me introduce just the overall program here for just quickly, because we need to get into the substance of the presentations. We have three different perspectives on distribution coming up here. One, first of all, will be from Daniel Ricardo Quiroga-Villamarin, and I'll introduce the speakers in a bit more detail as they come on. He will be talking about a distribution of goods and a material perspective on distribution. Second is Dr. Begoña Rodríguez Díaz, who will be on a distribution of natural resources in the world economy from a certain historical perspective. And then will be Saskia Millman, who will be talking about a distribution of, shall I say, of responsibility in the history of international law. So that is just a very brief overview. Our first speaker will be Daniel Ricardo Quiroga-Villamarin, and I hope I'm pronouncing that correctly. He's currently a doctoral student in international law plus international history at the Institut de Hautes Études Internationales et du Développement in Geneva, and he has a law degree from the Universidad de los Andes in Bogota. He's being supported during his doctoral studies by the Swiss National Science Foundation, and his research is on intersection of critical theory, global history, and international law, and especially concerned with global governance. And today he will be talking about his subject is Containing Globalization, a Material History of Transnational Law Through Shipping Containers. And so without further delay, I'll turn over to Daniel.
Thank you very much. I hope you can see me well and see the screen all right.
Yes, we can.
Thanks again to Stephen and to the organizers for the opportunity of being here. It's really a pleasure to see a lot of familiar faces and a lot of new faces in the audience. Today, I wanted to share with you some of the work I did last year over the course of my master's degree. And first, I wanted to try to place, let's say, this piece in the broader context of my master's dissertation. In particular, I'll be talking about the last normative chapter, which dealt with standardization of containers in and beyond the ISO, the International Organization for Standardization, here in Geneva. But as I said, this is only the last chapter, and the previous ones might touch interesting things for the purposes of our conversation. And I'm just going to highlight here the different pieces. I won't really go into depth in this other arguments erased in these pieces, but rather just remain here with this argument. Broadly, in this dissertation, let's say, the broader impulse behind my research agenda was in a way a dissatisfaction with the way international legal history had developed in the last 2 or 3 decades. And in particular, I got increasingly, let's say, concerned or preoccupied about the hegemony of intellectual or conceptual histories in our field. Not because they are not relevant or they're not important. I have used these methodologies myself, and I think they can have very critical, interesting purposes. But at the same time, throughout my master's studies, I did feel that they're very interesting to think of other ways to think about the past, present, and future of global governance. And in particular, what I wanted to do was to try to decenter our usual protagonists, which are invariably North Atlantic white European diplomats, doctrines, or legal ideas, to instead think, how could international legal history look like if at the center of the narrative we would place commodities, infrastructures, objects, and what could this, let's say, more material and more materialist-oriented international legal history, let's say, provide to the current discussion. What I wanted to do then was to draw perhaps from what is called very broadly in the humanities, their new materialisms, and in particular from science and technology studies, to try to think how can certain objects act, to paraphrase Langdon Winner, as the constitution of sorts, of a constitution of a socio-technical order in historical key. And in particular, in this piece, then, what I wanted to do was to apply this, let's say, theoretical insights into a particular series of normative debates related to the standardization of the materiality of containers, as I mentioned, in and beyond the ISO. I begin the paper, let's say my introduction really starts trying to highlight how, for me, at least when I started this project 2 years ago, it was quite striking how international lawyers seem to have very little to say about shipping containers, and public international lawyers in particular. In fact, when I talk with colleagues, more often than not, I was kindly nudged to talk with the trade and investment colleagues, instead of seeing this necessarily as a problem of, let's say, governments or regulation. And on the contrary, what I want to suggest is that, in fact, shipping containers have a lot to tell us about the international order. And perhaps the reason why we find them seemingly irrelevant is because we're not trained to see governance beyond textual mediums or beyond legal text. And what I wanted to do was to then a little bit push our ways of seeing and to try to understand containers not only as a commodity that we have known since Marx for quite a long time, that conceals certain types of metaphysical subtleties and theological niceties, but perhaps most importantly, that also acts as an infrastructure that has certain roles in the distribution of goods and ideas through certain channels throughout space and time. On the contrary, it seemed to me there was a broad literature in other fields regarding containerization. And I think what I wanted to do was to bring a little bit this literature in conversation to try to see how could we use this in international law. I just wanted to highlight here, let's say, different bodies of knowledge that I think have worked this very extensively. In particular, let's say the work coming from critical geography, from scholars of logistics, or even the work coming from contemporary artists, in my view, could have been very enlightening for the understanding of this shipping containers. What I try to do then is to, let's say, bring in the anthropology infrastructures, work that has been recently associated with other projects in international law, to try to think containers as, let's say, certain processes that help the movement and distribution of things in space. And just to give you an example of that, something I highlight in the paper, is that even nowadays, the mere sight of a shipping container produces a certain type of socio-technical imaginary of how governance at both of the domestic and international level should look like. And this is just an example of what the Colombian, I am a Colombian citizen, what the Colombian state uses to attract foreign investment, peppering this sort of videos with images of containers, good governance, labor friendliness, and so on. And if this is the case, I think the question for me was, how did this come to be? What I wanted to do then was to try to understand how this, let's say, very banal, seemingly insignificant, and at any rate, seemingly very technical material devices, such as metal boxes, can in fact tell us about how different people imagine the international order. And perhaps most importantly, of the interactions between, let's say, innovations in technical or technological devices and broader projects of regulation, world making, and world breaking. Now, I already mentioned a little bit that this really draws a little bit with the literature and materiality and international law, but perhaps the last thing I wanted to say on this is that something that I did want to do, and I here follow Alain Potash, and I cite him here in this slide, is that perhaps a big part of the literature and materiality, both in domestic, but perhaps more acutely in international law, has been perhaps too indulgent of the lawyer's sense of the law. We have studied extensively courtrooms, legal documents, legal files. And a little bit what I wanted to do was to take something a little bit more foreign, less, let's say, domesticated for international lawyers, and try to push this narrative of transnational regulation forward. Now, what is my argument? Basically, that throughout the 50s and 60s, 50s in the US, and perhaps more broadly 60s in the context of Geneva and the ISO and the different places it met, we had a normalization of practices of trade and commercial integration. And this is relevant, I suggest, because this series of practices, these very technical and material standards, would later come to set the rules of the global economy as we later, let's say, came to understand them and interact with them. And it's important to mention that at the moment I was working on this project, I was envisioning as let's say, the first historical chapter of a broader historical exploration that would go to the 70s, 80s, and 90s. For the time being, I have put that project on hold to do in a way, but I'll be more than happy to talk a little bit more about it later. But before I really tell you about container standardization, I think it makes sense to tell you a little bit more about how were things pre-containerized trade, just if anything, to make the contrast sensible and relevant for the kinds of conversation. And I think what's interesting about at least North Atlantic shipping before the advent of containerized shipping is that you can see a very different set of the similar abnormal shipping practices. And I took this image from the famous 50s movies on the waterfront that I think in a way captures a little bit the spirit in which in ports you would see very, very unstandardized, let's say, sorts of practices. At one port, you can approach one, let's say, understanding of commodities of labor in a very different way than a port in the same country. Most importantly, this made, let's say, docks very crowded, very cosmopolitan spaces. Alan Sekula, a contemporary artist, talks about ports as places of overlapping cosmopolitanisms, both bourgeois and proletarian. And I think this picture is interesting because just in a couple of decades, it would change rather drastically. And I think these two images from the port of Hamburg really shows us a little bit the transformations that ports experience. A containerized shipping really arrived in Hamburg only until the late 60s and 68. But just in a matter of decades, these places, which were, let's say, melting points of contention, social strife, urban and labor contestation, quickly became very sanitized, very sterile, very mechanical sorts of ports that are completely outside the purview of cities, citizens, labor movements, and so on. Now, something important before I get to this slide, something else that is important to note is that during this time, and let's say the post-World War II, but especially post-World War I shipping industry did really, let's say, follow a practice of very, let's say, aggressive seeking a profit. On the contrary, shipping was something that was very close to national interest and the national well-being, especially after the context of the two world wars. For European and North Atlantic players, it was very important to have a private fleet that could eventually become part of the military industrial complex. And as such, shipping was something that was very tightly regulated in domestic legislation. So for instance, in the US, if you wanted to run a shipping company, you had to employ local cargo men, local sailors, and you had to buy your boat that was made in the same jurisdiction. And I want to highlight a little bit later how all of this changed. Now, containers did not arrive out of the blue, and certainly they did not arrive in 1956, although most historians of containerization, maritime historians, do signal that this was a turning point. Of course, there were previous experiments in containerization across the board, but perhaps this is the most relevant or salient period because it was only until this time that you really try, or that, let's say, shipping magnates really try to use intermodal containerization. That is, containers that could serve for different transportation mediums, being that trains, boats, and so on and so on. And usually this story is told as a big man story, and especially US maritime historians tend to focus on Malcolm McLean, this figure that you see here in the center, as this heroic entrepreneur who tried to completely change the industry in a couple of decades. Other sorts of narratives are narratives that in a way place all the emphasis on the development of management, logistics, and corporate governance, while other narratives try to stress perhaps the determinism of the material and how the boxes, the cranes, and the ships are those who try to bring the narrative forward. What I wanted to do was, in a way, to avoid these three different narratives and instead, of course, contextualize McLean as an important figure without necessarily idealizing him as an entrepreneur, to rather see his connections to, let's say, US domestic legislation, US domestic subsidies, to try to show the ways in which this seemingly private business was very much dependent on national politics at that time. Now, the history usually goes as this. Initially, with the support of an engineer called Tandlinger from Brown Industries, throughout the 50s, you see the first experiments that McLean does towards containerization. In particular, in this time, you see the first time in the East Coast, there are attempts at containerized shipping, and eventually this gets replicated in the West Coast of the US by another company called Matson, also in the late 50s. However, all of this is incipient, and most importantly, you don't see any form of standardized practices yet. And then what I really try to show in the paper is how throughout the 50s, this led to a very pressing issue or pressing debate on how to standardize these sort of practices. On the one hand, as I told you, you had McLean and his company, which were pushing for 35 feet containers. On the West Coast, you had a different idea of 24 feet. The US Army, which of course was a very important player in shipping, especially after the Korean War and especially before the Vietnamese War, was pushing for a limited format of 10 feet. And what I tried to do is to show how this led to a constellation of public and private actors who all come with different proposals on how to standardize, let's say, global shipping and their sizes. In particular, in the US, you had the Maritime Administration, who in 1958 created its own committee to try to address this issue, also the American National Standards issue, and from a very different end, the National Defense Transport Association, which was perhaps more closely related to the Army and those sort of sectors. And my interest in the US, let's say, stems because I think this was really the dress rehearsal for a more broader global conversation that would occur in the early 60s when the US standardization authorities were bringing this issue towards the ISO at the international scale to try to replicate this conversation there. Now, before I tell you the details about this dispute, I did want to have a small aside about the relevance of standards in global governance. Perhaps this is not, let's say, an audience that is not unfamiliar with this, but as I try to create this project as a way to engage with more traditional international lawyers, this was something that was important, as many of them really didn't understand the regulatory or the legal aspect of this project. So just to go very briefly, what I'm trying to show is that there's a long history of, let's say, technical world making or technical internationalism that tries to put scientific expertise instead of, let's say, politics at the center of the agenda. And the ISO is a crucial player in this story. Most importantly, I draw from Foucault to try to say, look, these practices of standardization also imply a normalization, which is perhaps something that is clearer in the original French or in Spanish, normes techniques, normas técnicas. Most importantly, what I want to show is that even if these standards are seemingly voluntary and the companies can choose or not choose to comply with them, in practice, they do become a market requirement and they create all sorts of regulatory pressures to those involved in, let's say, international trade. Now, seeing that my time is quickly evaporating, I'll just finish a little bit telling you about the ISO Technical Committee 104, which is where these debates happened on the global level. What I found particularly interesting, or what I wanted to stress so much on the question of ISO standardization, is also to highlight the close relationship that this issue had with government subsidies and other forms of government aid, which were crucial for many of the incipient shipping companies of this time. What happened then at the ISO and also in the US a couple of years earlier is that it became clear that the best model would be to have a modular family with different container sizes. But even if that was the case, there were different proposals on how this could work. Some companies preferred certain types of sizes because they were more compatible with trains or with trucks, whereas others that came from shipping companies had a different vision of how this should look like. And what I tried to show is that at the end, we have perhaps the familiar formula family of 10, 20, 30 feet that we now use nowadays. Most importantly, what I tried to flesh out a little bit in this part of the paper is that this was not simply, let's say, an US imposition, not because the US is not willing to impose, but rather because I wanted to show how different companies had different transport philosophies and how at the end it was really the Europeans who really brought, let's say, the US standards onto the table, partly because they were not able to have a consensus among them. Crucial among all of this is the absence of any participation from what we now call the Global South. Of course, for many reasons, partly due to time, partly due to decolonization, partly due to the, let's say, invested interest behind shipping and so on. Now, my time is really finishing, so I just want to conclude saying a little bit why did I think this project is important, was important in the time I was undertaking it. I wanted to, in a way, make a contribution to the debates about the history of capitalism by highlighting the relevance of regulation from a legal history perspective. because it seemed to me that most histories of globalization and by the same token capitalism, especially let's say the older narratives, not as much nowadays, really tell us a history of law as deregulation. Law is something that you remove for globalization or capitalism to emerge. And on the contrary, what I wanted to do with my very modest shipping containers was to tell you, well, any process of market making, especially globally, requires many instances of regulation. And these metal boxes are perhaps just one of the many instances in which regulation, transnational regulation, takes place. I prefer to stop here and to yield the floor to my colleagues, but I really look forward to your comments and questions. Thanks again for your time and attention.
Yes, thank you very much, Danielle. That's a very interesting talk. And I think especially the way that you've asked people to see governance in a way beyond just legal texts and to have a broader perspective on just what is meant by governance. And but there will be room for discussion of this with the general audience later on. Our next speaker is Dr. Begoña Rodríguez Díaz. She's a lecturer at the appropriately named Universidad Francisco de Vitoria in Madrid. And she has had much experience in teaching both international law and European Union law. And she is a member of a research community that analyzes the anthropological conceptions underlying law and also has an interest in the rights of disabled people in international law. So her topic here is on distribution of natural resources and the contribution that the thinking of Vitoria has made to that. So the floor is yours.
Thank you very much. Well, good morning, everyone. I'm very pleased to be here with you. I'd like to start by thanking the organizers for not having given up the organization of this Congress, which we were very much looking forward since last year. So thank you all, and congratulations to Danielle. I was really impressed by your presentation. I'm going to have a very different approach. This is going to be much more historical. So I also have a presentation, if I can find it. Let me share it. Not yet. Okay, can you see the screen now?
Yes, we can see it. That's fine.
Okay, well, it's a very simple presentation just to help to follow up. I can't prevent it to say I'm a lecturer. So let me, okay. The title of this paper is Lessons from the Past, as you see, International Law and Distribution according to Francisco de Vitoria. As you all know, this Dominic Frank has been considered one of the fathers of modern international law. And he also gives name to the university I come from. So I was very keen in researching a little bit more about him. He's very well known, especially for his contribution to the rights of the Indians, his doctrine on the just war, and his conception of the international community, what he called totus orbis, based on the unity of all mankind, whose goal is the common good. So I'm going to be focusing on this concept. So the idea of this paper was to analyze if any of the ideas that Vitoria held could be used to give us some answers to current global challenges regarding international law and distribution, of course. So first, this is the goal of this paper, and you can see the structure. First of all, we will briefly present his understanding of the law of nations as derived from natural law, and also his idea of totus orbis. And this requires exploring his anthropological conception underlying his thinking, which directly influenced all his proposals. As Andrew said, I am a part of a group that we're researching on the conception of men underlying each of the, many law and case law. And I found it very interesting to try to delve onto Vitoria's thinking in this way. Secondly, we try to summarize Vitoria's thinking regarding the use societatis et communicationis, and accordingly, the right to travel and settle, the right to trade, and the right to use and enjoy all goods of a foreign land, as long as you don't cause any prejudice to the inhabitants of that land. That we're going to link this with his doctrine of the common goods. And lastly, we'll just focus on the main topic of this paper, which is if it would make sense to recover any of Vitoria's doctrine when rethinking current immigration laws, the role of the United Nations, and also the use and enjoyment of the common goods. So just as an introduction, I guess you are all familiar with this, but let me remind you that, well, Vitoria was born at the end of the 15th century. He was part of the school of Salamanca, where he was an academic. Well, he had previously studied in Paris. He was a Dominican friar, and he was very influential in his time. One of his main contributions was his defense of the rights of the so-called Indians, the inhabitants of the new lands just discovered by Spain in America. At that time, there was a theological discussion about if those Indians were actually human or not. And Vitoria defended the humanity of Indians and consequently their dignity and therefore their rights, even the rights to property and the rights of to their own territories, which was very revolutionary at the time, and it influenced the approach of from Spain to the new land. Okay, so just as an introduction, let's start with it then. So the law of nations. First of all, we're going to start with the first consideration, how his anthropological conception influenced his thinking. So with another words, what idea of man underlines his thinking? On one hand, we have to have in mind that he emphasized the use of reason as the main difference between human and other living beings. Since men were created in the image of God, of course, he was a theologian as well. He was not only a jurist. This use of reason presupposes, on one hand, the ability to choose, that means freedom, which is one of the main features of human nature, and also the ability to suffer justice or to suffer injury. We could call it also a vulnerability. This use of reason is the condition to the ability of dominion. So we'll come back to this idea later on. On the other hand, as we said, his anthropological conception stemmed from his faith. As I said, he was a Dominican friar, so he considered that all men were created by God and children of God, and in that sense, they were all entitled to certain rights, and they all formed what he called societas naturalis. As we will see from this idea of man, he concludes that society is not a human invention. It's not either a result of a convention, but it has a natural origin. If you allow me to quote him, he said, the source of and origin of cities and republics was not the invention of men, nor is it to be considered as something artificial, but as something that comes from nature itself, which for defense and conservation suggested this mode of social living to mortals. So society is connatural, and also at the same time civil power. He did defend that it was necessary to have some kind of force or power to govern those societies, and he put the origin also in nature. But other than the civil power from the republics, Vitoria's aspiration was a step further. He claimed that although the civil power of the republics was lawful, the different political communities should join in search of an ideal international political unity. He used the word orb, I think it is in English, to refer to the unity of peoples, grounded on the same human nature that they all shared. And then, so for him, all peoples constituted a single international entity that he called totus orbis, including non-Christian communities, which was also revolutionary at the time, because as you know, at that time, it was very Eurocentric. Of course, this was the beginning of the knowing other continents, further continents. And the Christian countries had a relationship with each other, but not with non-Christian countries. But he said the international community, the totus orbis, is composed by everyone, no distinction regarding race or people or wherever. There is a very known quote about how this whole world, he said, is in somehow a commonwealth. Okay, and from this we can see the law of nations, which has been given by the authority of the whole world, and it binds all nations. This totus orbis has also a natural origin. He made a parallelism between the natural groupings of individuals and subject to the authority of the civil republic and the grouping or the community of republics that form the totus orbis. Vitoria considered that the law of nations should prevail over the interest of the single republics, and I think this is very important. And well, we still have it. The international law prevails over domestic law, but I think it is very important, and we have to come back to this idea later on. He did sustain that because considering that even if republics were perfect political communities, their sovereignty was not absolute because they were subject to a higher common good of the whole world, what he called bonum commune totus orbis, and that limited their freedom of political action. So this is the idea I want to focus on for our global current challenges, how any common good could prevail over the national interest and could limit the freedom of action of the national, of the states. For Vitoria, the idea of common good derives from the mutual solidarity and interdependence existing between the nations and the whole human race. Jus gentium is common to all mankind, is universally applicable, and can be recognized by the use of reason. So just have in mind, he defined the man by his use of reason, and again, he defined the law of nations as the one that you can learn, you can know its content by the use of reason. We're going to pass now to our second part of this presentation, where we're going to focus on one of his contributions, which is the Ius Naturalis Societatis and Communicationis. The rights deriving from this principle are, of course, universal and valid for all peoples, and they are actually, they have a legal character, since any kind of infraction would have legal consequences, punishable legal consequences. So we're going to name them and just go briefly through them. The right to settle, to travel and settle, right to trade, and the right of communication. We're going to see them in more detail now. I have brought a few quotes from Vitoria. This is from the right to transit or the right to settle in a foreign land. And it also implies the obligation to welcome guests. Furthermore, Vitoria also defends ius soli, that is the right to get the citizenship from the land you have been born. I don't think I've added this quote here, but anyway. So if you just go through them, he's always thinking on his point of departure is the nature. So he says things like, it is considered inhuman to treat guests and passersby badly without any specific reason. So as it is considered inhuman, we should welcome them. We should behave well towards foreigners. We shouldn't prevent them settling in our own country as long as they don't harm us or they don't offend us in any way. It is not lawful either to banish foreigners without any kind of fault. So this could have very important implications if we did apply it today. I leave it for the last point of the presentation. Right to trade, of course, this was made in interest of the Spanish Empire arriving to the land, but he thought as well that it could be stemming from nature. He said nature has established a certain kinship as a force among all men, so foreigners should be allowed to trade. As long, he's always adding this kind of this expression, as long as it doesn't harm anyone. And this is also very important. And we're going to focus mainly in this one, the right of communication and sharing of the commons. See if you can read some of his quotes. One of the main ones is this one in the first paragraph. He says, at the beginning of the war, all things being common, anyone was allowed to go and travel through the regions and so on. All things being common. So this was his idea. Things were common, and then they were kind of appropriated by the states. And still there are some goods that are always common, such as water courses and the sea, rivers, harbors, and so on. So no one should be able to forbid their use. What else? Not only I don't know, the right to navigate, for example, in the open sea, but also the use and enjoyment of these goods, even if they are in a different territory, as long as they don't harm any other one. For example, the right to extract gold from the rivers or pearls, he says fishing pearls, as long as they don't suffer any prejudice. We cannot explain now in detail the great influence Vittoria's thinking had at his own time, even if some of his ideas were not implemented in the context of the emergence of the sovereign nation states, where limitations to free movement of persons were out of question in order to protect their borders. Sorry, someone was coming in. So then we'll go with the final piece of this presentation. How far might Vittoria's thinking inspire the answer to our current global challenges? The legacy from Vittoria is very wide, very vast. We don't aim to analyze it all now, but I would like just to focus on one on his most unknown contributions, his doctrine on the common goods. Vittoria's theory of dominion argued that common goods were originally universal, as we read, and thus that they might be used and enjoyed by everyone. He even defended the right to acquire res nullius, that is, unknown goods, as long as it didn't cause prejudice to others. So the link between Vittoria's ideas and the current debate on the global commons has not received, I think, enough attention from the scholars, some of them, but not many. And yet the challenge is very similar. I just put it in that table. Now, how to care for those commons without dividing them and without allowing private ownership. We are referring to global, what we call nowadays global commons, such as the deep seabed, high seas, outer space, that they have been considered common heritage of mankind. I'm just going to go very briefly to some of them. There is an international regime of some of those global commons. For example, while in the UN Convention of the Law of the Seas, there was a system foreseen to administer the resources lying in the deep seabed and to compensate those countries unable to participate in them. The 1994 implementation agreement meant the shift towards exploitation of the sea regardless of biological interest. This goes against the first principle of modern international environmental law as defined by the International Court of Justice, 1997. I'm just going to quote, I don't have it here in the presentation, I'm just going to quote the ICJ when it said, natural resources are not individually but collectively owned A principle of their use is that they should be used for the maximum service of people. And also a little bit later, in that case, very well-known case, the New Dam in 1997, it said, "We have entered an era of international law in which international law subserves not only the interests of individual states, but looks beyond them and their parochial concerns to the greater interest of humanity and planetary welfare." With a different example, for example, the high seas, the traditional freedoms of navigation, fishing, trading have led way to a more regulated system in order to protect some countries that didn't participate in the formation of the law of the seas, but also to prevent overexploitation. Overexploitation was not a challenge at Vitoria's time, but still we can find traces of his thinking in today's system. For example, when we forbid exploitation that could prejudice others. I'm not going to analyze any other similar regimes, such as the outer space or the Antarctic, where the category of common heritage mankind apply, but I would like to call the attention to other areas that are not considered global commons, but global concerns, and as such they should be taken into account, such as tropical rainforest, preservation of biological diversity, ozone preservation. Vitoria defended, as we said earlier, that the law of nations should prevail over the interest of the nations individually considered. The problem is, has our global system an authority powerful enough to impose it? Are we too far from Vitoria's idea? What can we learn from his thinking? I'm about to finish now. Much could be said also about the right to travel and settle. Is it possible to comply with this right now? Could we say that people could travel and settle as long as they don't cause any harm to the land they arrive? Do we consider this stems from natural law, as Vitoria did? And if we do, what consequences could it have? Because we shall remember that it should prevail over domestic law in case we consider it is. And what about the protection of human rights? Vitoria, as I said, was a revolutionary in his time by recognizing the human nature of the Amerindians and their rights. But there are other categories of people that have been prevented of enjoying their human rights, such as depending on their race for a long time, or their sex, or their disability, or so on. So what is the basis of our current protection system of human rights? What is the founding of it? For a long time, it has been the same as Vitoria held, the common human dignity, either we consider us children of God or not. But nowadays, we're leaving aside this consideration based on our nature and defining our rights, basing them on the free will and the right to autodetermination. So what could be the consequences for those? I'm afraid I have come to the end of this presentation with more questions than answers. I would like to conclude by encouraging all of us to delve into the roots of the current rules of distribution. Why do we consider there are goods that are common heritage of the mankind? What should be the regime applicable to them? What could we do to promote they benefit the whole mankind, and the use and enjoyment by some do not imply prejudice to others? Is the UN an effective authority of the international community? And what could be done from the academia? I hope you find these questions challenging, and that we keep contributing to this debate with in the search of as well argued answers as Vitoria had at his time. Thank you very much for listening.
Yes, thank you very much. And that was a very stimulating talk on the relevance of Vitoria's thought from centuries ago till today. And I was particularly taken by the interplay between the dictates of the law of nature on the one hand and the interplay with human free choice on the other. It reminds me of what John Stuart Mill said, talking about this issue from the material standpoint, and this goes back to Danielle's talk in spirit at least, where Mill said that the laws of production are iron laws of nature and are unchangeable. The distribution of human product, on the other hand, is a matter of free choice. Anyway, we can explore such thoughts later in the question and answer period. For now, we have our third speaker, who is Saskia Millman. She is a doctoral candidate at the University of Glasgow. And as a matter of fact, with an impressive title, the Lord Kelvin Adam Smith doctoral candidate. Neither of those was an international lawyer, but they are eminent indeed. She has studied both at the University of Munich and University of Edinburgh, and where she was a student of mine, as a matter of fact. And you often hear it said that teachers excel their the students exceed their teachers and such. Well, you may see that before your very eyes here. She will be talking about an area of her doctoral studies, which is the role of non-member states of the League of Nations in the League system and contributions which they made, and a comparison of involvement by League members and non-League members. So without further ado, I'll turn this over to Saskia.
Thank you, Stephen, and also thank you for those very nice words. Now, you've created quite an expectation for this presentation. I hope I can meet it. And also from me, thanks to the organizers. I'm very happy that I and all of us now get a chance to finally have our presentations after the unfortunate delay due to COVID. So as Stephen said, I'm going to present a paper, or rather part of my PhD, in fact, on non-member engagement in the League of Nations. And this particular presentation focuses on the question, did membership matter? So what usually is discussed in terms of the League of Nations is that it failed because important states like the United States, for example, were not members of the organization. And as you can see from this not very nicely colored map, membership in the League of Nations indeed was quite difficult, because you've had a number of states that joined, eventually they withdrew, but at the same time, some states might have not yet joined, but joined later, withdrew, then maybe joined again. So there were very many non-members, just not necessarily all at the same time. But what I'm going to do now is, or what I already did, in fact, I've focused on this non-member engagement, specifically in technical activities. It is a bit unfortunate maybe that the League is very often only reduced to its arguably indeed very failed attempt to safeguard the peace. However, the League focused on a number of technical activities like the prohibition of trafficking in opium, or the fight against the traffic in women. It facilitated trade talks, and also, of course, did a lot on minority protection, just to name a few. And in all of those technical activities, non-members played an important role. So the main questions for this presentation and for my PhD are so how did states that chose not to be members for whatever reasons nevertheless contribute to the League's activities, and can different levels of participation as non-members be distinguished? And then in relation to that, so how open was this international organization? And maybe the provocative question, did membership matter at all outside of administrative purposes or procedures? And with this in mind, as you can see, this entire thesis is very much based on archival sources and, of course, doctrinal interpretation. But those kind of reports are, well, quite often, you can find them quite often in the League of Nations archives in Geneva, where this non-member engagement was discussed by Secretariat members, or sometimes even by representatives of member states that addressed questions to the Secretariat. But what I was able to show is that collaboration was possible as early as 1920, so from the very moment of the existence of this organization, and it increased over time. And this question of non-member engagement was also discussed quite early on from the start. I mean, this particular document is from 1940, so this is obviously rather an example of the very end of the League of Nations activities. However, the League was always very open to this, well, I will discuss some critical aspects later on, but in general, they endorsed this and they very much supported non-member involvement, of course, in the hope that they would eventually join as members. And what I would like to say on this is there was this dichotomy from the start. So yes, you did have this organization based on membership, and you had this entire procedure, how to gain membership. Also, not everyone who wanted to be a member was admitted. So it wasn't that open maybe in that regard. However, it still, as I said, allowed this non-member involvement. And maybe if we look back a bit in history, one could argue that the League of Nations was in fact just a more permanent and structured form of a conference. So I guess it really depends on your definition of what an international organization is or was at that time, whether you would say, for example, the Congress of Vienna was an international organization. I know there are scholars that do say that, but there are, of course, also scholars that say, no, the League of Nations was indeed the very first proper global world organization. But still, we have the benefit of hindsight, of course, but the actors at that time didn't. And for them, they were quite used to this kind of conference diplomacy and conference lawmaking. So perhaps this was just nothing controversial. Of course, you would continue with this on at the same basis as you would involve members. But be that as it may, what is also quite interesting, I believe, is that the League as an actor had diplomatic relations with non-members. So it's not only the Secretariat as such that would send messages, letters, correspondence. Yes, of course, they did do that. However, they also organized diplomatic visits. So you would send a delegation of the League to the United States quite regularly, for example. Whenever, for example, there was a new president elected, or there might have been an internal political shift in the United States, they would send a delegation that would be there for 1 or 2 weeks even, and meet with high-ranking political officials, with the president, with the foreign secretary, and so on. Not really to convince them to join, because they knew there wasn't any political will in the United States to join the League, but just to, try and get more support for technical activities, and just have a closer relationship, really. And outside of this, of course, then were conferences. So this was the perhaps more standard possibility of engagement. So non-members were both invited to conferences, but sometimes they would also proactively ask whether they could join those conferences. Brazil, Germany, the United States, Turkey, and the USSR were quite active in that regard, but they weren't the only non-member states. So Costa Rica, for example, or Ecuador, they also participated, but they picked the topics very carefully. So you can see that there is also a difference. While Brazil and Germany, for example, just participated at almost anything, those states, they just participated in very specific thematical things. So the traffic in women, for example, for Costa Rica or Ecuador, opium was interesting to them, or perhaps more things related to the law of the sea, these kind of things, but not necessarily other topics. What also happened is then what I think mentioned before, is that there was some criticism, or rather some worry, how this develops. So the Maqui Paolucci di Calboni Barona, who was a director and high-ranking member of the Secretariat, he said in one of the directors' meetings, it would create a dangerous precedent if a member on leaving the League could still play the part it wished in the technical organizations. such a facility might rob withdrawal of its sting. The position of the United States of America was exceptional as it had never been a member. So at that time, he said this in 1928, you were in a situation where some states had withdrawn from membership and they kind of still wanted to be active in those organizations. So maybe if you want to use the phrase, have the cake and eat it too. So they didn't want to have all the responsibility, but they do wanted to have the benefits. And it was agreed at this meeting there should be a 2-year probation period where they would just allow this to happen. And then they wanted to assess whether the states used this method and withdrew while keeping active basically had the cake and eat it, or whether this was the exception. And this probation period elapsed in 1930 and they didn't change it, but still, I will talk about this later a bit more. There was a very diverse approach for non-member states. What also existed is that individuals that were nationals of non-member states were asked to join committees. For example, Albert Einstein was asked to join the Committee on Intellectual Cooperation in 1922, when Germany, of course, was not a member of the League, but also states as such were invited to send any representative they pleased. And the United States was invited to almost everything, but they rejected quite a lot of invitations. For example, they didn't want to be in the Disarmament Committee or even the Economic and Financial Committee, whereas they did accept the invitation to the Traffic and Women Committee or the invitation to the Transit section. And also then Germany as a state was invited to quite a few committees, for example, the Hygiene section, also the Opium board, and they did accept those kind of invitations. So what is interesting, and you can see this here, Brazil was quite adamant, for example, to keep their membership in the ILO. And the membership in the ILO was connected to the membership in the League. So you couldn't split those things. You couldn't join one and not the other. However, they were quite successful in keeping their ILO membership. And they also continued to pay their membership fees. And this is something interesting that I found for all non-member states that participated in these committees. All of them paid contribution. So it wasn't a membership fee as such, it was a specific fee for this specific technical activity that would only be used for work done in the section of this activity. And Brazil even went a bit further ahead. So she even, when she already had withdrawn as a member, proposed that her Centre of Leprosy should be put under the auspices of the League, wanting to have this closer technical cooperation, while not wanting a political cooperation. So as I said, US accepted some invitations, rejected others. They also contributed financially a lot, but also American citizens, so private citizens, contributed to the League, and also American organizations like the Rockefeller Foundation, for example, would give, I don't know if you want to call it donations, maybe that would be the more appropriate word. At least they gave money to the League for specific activities. And then, as I mentioned earlier, it's a bit difficult to ascertain whether states misused this or not. There were some states like Chile, Hungary, or Peru who kept all of their representatives. Other states tended to pick and choose. So they withdrew some of their representatives in areas where they were not interested, and so on. And then, of course, you have the other group of non-members who didn't really want to cooperate or work with the League. You had some states like Ecuador or Egypt that would only participate in conferences and only in a few that they were interested in. And then you would have states, and actually this is the complete list, 4 of them, who would indeed never cooperate with the League: Afghanistan, Hejaz at that time, Bhutan and Nepal. And they didn't really answer correspondence. They didn't answer any invitations. Some of them, I must say, like Afghanistan, were actually not even invited to anything anyway. But all of them did receive correspondence, because the League of Nations made sure they had an updated list of their non-member states, or what they would define as states anyway, to send regular correspondence. And they did also send it to these states, but they never received a reply, or at least the reply isn't in the archive. So it might have been lost if there was a reply. And this is, again, just an example of how these lists looked like, where, yeah, states that had given notice, for example, then it was said, oh, their last attendance in this committee was in 37 or 38. But here, Hungary, for example, still attended it in the process of leaving. And then here, member states like the US that regularly attended it, or states that had left, that and Italy, obviously, for political reasons, ceased to attend. And these kind of things exist for all committees, which is quite interesting. So, and yeah, coming to an end to my presentation. So there are 4 stages, essentially, a 4-stage framework that I could identify. So there are states that, or there were states rather, that participated in League committees and fully collaborated in technical activities. Then there were states that only ratified conventions and treaties under the auspices of the League. The 3rd stage would be states that honored agreements after departure, but didn't enter any new ones, and also didn't attend any new conferences. And of course, the last stage, states that ceased all communication, or indeed never even entered communication or collaboration. So the conclusion would be here that the League was designed and functioned as a platform that enabled and encouraged participation from third parties from the very beginning of its creation, and different levels of engagement can be distinguished. It was therefore an open organization, in my opinion, and I believe indeed that membership was not a relevant concept for engagement, and it only had administrative benefits. So as a maybe historical follow-up, it follows therefore that a membership in the League was not a deciding factor in the success of the organization. And yeah, with this, I'd like to thank you all for listening, and I look forward to your questions and to the discussion.
Okay, great. Thank you, Saskia. And that was a very interesting talk, and connecting with some of the things that others have said, that we should learn to look at governance and indeed other issues as well, outside just the formal context of just the list of member states, that governance is something that is broader than that, and we need to have a more sensitive eye for these things. And all 3 of these papers have helped in that general direction, and all on the subject of distribution of various different things. Anyway, because of the heroic restraint which our panelists have exercised, there is time for discussion, and the commandant of the discussion will be Professor Chadwick. So I will turn over to her, and she will moderate.
Thank you, Stephen, and thanks to all the panelists for the very interesting presentations. So in terms of how the Q&A will work, there are 2 options for asking a question. First, you can choose to address your question to the panelists orally, and to do so, you can raise your hands on the Zoom function, and then we will indicate when you can speak, or you can write to me in the chat and let me know just that you have a question. Second, if you prefer not to address the panel directly, or perhaps you don't want to be recorded, you could write your question out in the general chat, and I will then read your question to the panelists. Please do remember to specify which panel member your question is addressed to, or whether it is in fact addressed to all of the panelists. So I'm already seeing that we have a hand raised here. So perhaps I'll take 2 to start with. So I see Yuri and Stephanie. Yuri, would you like to? Yeah, thanks.
Good day. I would like to thank presenters for exciting presentations, and my question is to Saskia. I'd like to ask what are main differences between League of Nations and United Nations in cooperation with the third parties, and especially in regard to non-internationally recognized states? Thank you.
Shall I answer right away? Or?
Maybe we'll just take Stephanie's question and then we'll have a round of answers. Thanks.
Hello, everyone. Thank you for the interesting presentation. So my question is for Begoña Díaz Rodríguez. So my question is the following. The presenter takes Vitoria's writing as a basis for tackling future challenges. And I'm wondering if there is not a danger here in the decontextualization of Victoria's work. I mean, Victoria's work has been saying, yes, Indians are humans, but they're not sovereign, which has justified the war of the Spaniards against the Indians. And also he has said people should welcome each other, basically saying Indians should welcome the Spaniards as if it was a symmetrical relationship, which it wasn't. So I think that authors such as Anthony Angie and others have showed how Victoria's writing have basically given a legal foundation to the empire and subsequent extraction and genocide, and what we can still see today. So I would like to ask Begoña what is her reaction to this very critical scholarship on Victoria's writing.
Great. Saskia, would you like to respond first?
Yes, thank you. And thank you, Yuri, for your question. And I think that's a really, really interesting one because, well, for many reasons. So the League of Nations actually did not make statehood necessary for membership. What was necessary was self-governance. And quite a few colonies, for example, who of course were not sovereign, were able to join. But even, for example, the Free City of Danzig was on a list of potential entities that could join. So that is, I think, the main difference in membership, that statehood was not at all required. And of course, the United Nations then changed this, and they made it quite, maybe as a result from the League's practice. I frankly don't know whether that is the case, but it's certainly a possibility. But they, of course, made statehood mandatory as the deciding factor whether well, an entity can join or not. And also, the UN had a very different approach to cooperate with non-members. And now let's first talk about states which statehood was not under any dispute, like Germany, for example, for a long time, or Switzerland, who didn't join for some time. And they basically ignored them. So when U Thant was still Secretary General, he was internally criticized for not trying to include those non-member states and allow them some form of, I don't know, either position where they could at least participate in negotiations, or an observer status, something like that. That of course all came later, so they have an observer statute and these kind of things. But at the very beginning, the UN seemed to be quite the polar opposite of what the League was, and they didn't want to be that open. They wanted to have members, and they were in the vicinity, and they could participate and discuss. And then they had everyone that was outside, and they didn't want to cooperate. And nowadays, of course, regards to territories which statehood may be under dispute, or which aren't universally recognized, or whatever that might be, the UN has I guess a little bit more open policy, because at least there's this observer status, and they have a foot in the door. And that wasn't necessarily the case for the League, because if you were an entity that wasn't self-governing, then they weren't interested in you. And if they believed you weren't self-governing because you just didn't meet the standard, because you might have not been a Western powerful nation, then they also weren't interested in you at all. So, and this was a very long answer, I'm sorry for that.
Thank you, Saskia. Begoña, would you like to respond?
Thank you, Stephanie. Thank you for your question. I do think it is very important to read him in his context, and in order to be able to, I don't know how to say that, evaluate him rightly and fairly. Okay, so it is true that he justified the conquest, but at the very same time, he was revolutionary in the sense that, for example, he said not the Pope or the Emperor had any kind of temporal power over the people living in America. So that was at the time actually revolutionary, because there was I don't know how to say that in English, no, bula, actually given the Spanish Empire power to go there and conquest everything they found, but he's the one putting on limits and questioning the power of the Pope and the Emperor. So this is quite, I mean, I think this was quite revolutionary at the time. Also, the consideration of the native people there as humans, even if, of course, he was living in the 16th century and he was not against slavery as such and so on, but he did think that people were all born equal and they were all children of God. And as such, he didn't question that they had right to their own properties or territories. It doesn't mean there were no abuses in those lands on behalf of Spain, but he denounced them. So he was not supporting any kind of abuse or I don't know, taking away their territories or their properties. So even if those things somehow happened, I do not agree there was a genocide. Actually, if you do go there, you can see that there were, I mean, of course, there were things that shouldn't have happened, but we have to think of them with the mentality of the 16th century. They got mixed with them. So the people coming from Spain and Portugal, they call them los mestizos. I don't know how to say that either. Maybe Daniel can help me with that. So there were things that happened in that time that shouldn't have happened, but he denounced them. So it doesn't mean there were no abuses. It means that, well, things are not perfect, of course. And on the other hand, when he gave 8 principles to justify the conquest on behalf of Spain, and even if he did so at the very end, the first principles, those ones are the ones that I have quoted. I think they are actually very important in the time they were given. I don't know if you all agree or not, but I hope I have answered your question, Stephanie. Thank you.
I do not agree, but thank you for your answer.
Okay, so I'm not seeing any other, oh no, I do see that there's a question for Chris, but I wondered if anybody else wanted to come in on this issue, perhaps, if there were no other pressing questions. We still have a bit of time, if anybody wanted to respond. Okay, in that case, Chris, we have a question from Chris. Oh, and then, sorry, Stephanie, would you wanting to respond again, or?
I don't want to take anybody else's time. I just have another comment as to
maybe a brief response if you would like, and then we can move to Chris.
Okay, so basically, Victoria says that Indians are not sovereign, and therefore they're not allowed to repel the Spaniards. So they're not allowed to repel the Spaniards, but the Spaniards are allowed to wage war against the Indians because the Indians are not justified in doing war, okay? So he's justifying the war of the Spaniards against the Indians as a retaliation if the Indians push them back. So he is justifying violence against the Indians. This is the first thing. The second thing depends on the definition of genocide, right? But I mean, I lived in Argentina for most of my life, so I mean, I know the continent, right? Massive violation of human rights, displacement, separation of children from their parents, bringing in diseases, etc. I mean, if this doesn't qualify as a genocide, I don't know what does, right? But I'll leave it there. And I think that everybody has different opinions on that. Well, some people have different opinions.
I do respect, I mean, just not to focus the debate only on this point, just to clarify something. Most of the people who died in America, even if there were abuses, I'm not denying there were abuses. I do think he was a supporter of the rights of the Indians, and he was denouncing them, but even though most of the people dying there, they died because of the Spanish flu. Well, it wasn't called Spanish flu, but it was some kind of virus the Spaniards brought from Spain. And this is quite well documented as well. So even if there were those abuses, I'm not trying to deny them, most of the people dying then was because of those flus coming from Spain. Well, that's it. I mean, we could, you have my contact details if you want to have a chat later on, if you want to.
Okay, so maybe in the interest of making sure we have questions for all of the panelists, Chris, would you like to ask a question?
Yes, thank you. And my question is in fact for everyone. One thing I think came out of all of the presentations was a look at the paths not taken. The idea of possibilities, whether or not that's other technical standards, whether or not that's other approaches to dealing with third parties, or other historical thoughts that were not built upon. How much do you think that we can actually recapture some of the notions and some of the benefits from those previous modes of thinking about things, or how much are they actually now in the past and we can't then necessarily reclaim some of those things? It's really just to get the perspective on what we can materially pick out from those historical moments.
Would anyone like to come in to Chris's question?
Yeah, if the others don't want to start, I'm happy to start. Yeah, thank you for your question, Chris. I think, particularly if we look at Brexit at the moment, it would be interesting to, well, at least entertain the thought that membership alone isn't that necessary to cooperate with an international organization, and that there might be some activities that are not political, but more, yeah, if you want to call it technical, that where cooperation is possible, and that doesn't necessitate membership. And I mean, the EU has some different treaty regimes where, yeah, states that are not members of the European Union kind of can also join, but that's very broad. If you wanted to maybe look at more detailed, areas of activity and be more pragmatic, I think that would be an interesting thought. I'm not sure whether it's politically wise to do so, but I think in general it would be something that we can learn about, that sometimes pragmatism isn't the worst choice. If some things can get done, and there is some benefit for everyone, and especially for the people, because all of those activities for the League were, of course, not all of them, but many, focused on making people's lives better.
Anybody else? Daniel, did I see your hand? Yeah.
No, I think it's a good question, Christopher, and I thank you for it. I think that for a very long time, doing international legal history was precisely that, was the study of the paths not taken, the study of contingency, and it's all the rage. I mean, there was just literally a couple of weeks ago a wonderful volume I did on that. I must admit, I'm not that interested in those sorts of questions anymore. I think that, of course, contingency is fascinating, and we need to study the many ways why things happening in unexpected ways. But I think in this piece, at least, I was much more concerned with structures. Why do things keep happening the same way all over and over? And I think the conversation that we were having just a couple of seconds ago is a very good example of that. Why do we keep having this very Francoist and fascist interpretation of Vitoria being put out as an interpretive view of legal history? Why did that happen in the 30s? Why did it happen in the 40s? As Ignacio Larrañaga has told quite well. Why does it keep happening today? Those are the kind of structural problems I'm interested in, much more than the paths not taken or the contingencies ahead of us.
Anyone else want to respond to Chris's question? Okay, I think we also have a question from Gail in that case.
Yes, thank you everyone for your papers. I had a question for Daniel, and it was on the idea of structures or structures of thought. And I was wondering why, if you thought that perhaps, or why is it that shipping containers and are maybe less the focal point for public international lawyers? And is it the fact that we don't have a clear enough spatial conception of private actors in the discipline of international law?
Thank you very much, Gail. I think that's an issue that increasingly is being questioned all across the board. And I think it is the long-standing division between the idea that there are certain things that are private and that are economic, and on the other hand, that there are certain ideas that are public and sovereign. And I am not the first and probably not the last person to try to question that critique. I am also building on a lot of work of feminist previous scholarship, of people who are nowadays trying to bridge the gap between private international law, public international law, or more broadly of doing political economy of things that do not seem very, let's say, proper to a political economy analysis. But I think that's precisely the kinds of conversations we need to be pushing. And I must admit that at the end of this project, I was somewhat wary of continuing to do that. And for the PhD, I backed down to a much more traditional and public sort of project. And I did so very aware of the potential, challenges one faces as a young junior scholar trying to pitch a too radical proposal later in the market and so on. But I think that definitely to bring down those binaries and to think of them structurally are one of the tasks of our generation of critical scholars.
Thanks, Daniel. So I don't see any other questions unless I'm missing any hands. Would anybody else like to ask a question, or shall we wrap things up? Okay, so maybe you can all join me in thanking our speakers for their time today and for their presentations. And we will have a 10-minute break, I think, just before we move on to the keynote. Thank you very much, everyone. Stephen, would you like to say a final word?
Just thank you to everybody, to yourself for chairing the question and answer, and for, most of all, for our three panelists for extremely stimulating papers. So thank you to the panelists and more broadly to everyone.